Apologies for absence. I have received here Senator Webby, who and Mrs. Cuthbert Flynn also has tendered an apology. Yes. I will be drawn. I won't be drawn in that loose conversation. Any other apologies?
Sir, just given the composition of the committee today, I want to move for the suspension of the standing order so we can reject the bill.
You know, no, it's the clearest indication. It is the clearest indication of the trust.
That was a joke.
Of the trust and confidence in your abilities. Don't abuse it.
I want the record note that was a joke.
Yes. Member Gale has indicated that he's on his way. He has left his offices, so we should expect him any moment now. Again, our work as a committee continues today. I believe on the last occasion, which was Monday of last week, we had broadly set the schedule for this week, which was certainly to continue on clause 4 of the bill that deals with the definition of the key terms. Also, we have reserved the afternoon session to hear submissions from the JGRA. Certainly I have not had sight of any written.
Yes.
Oh, there is. Where is it?
You don't have it?
No. I gather that, yes, so there is in fact correspondence from them. They have confirmed that they will be here. Yes, so they have, I am being advised that they have confirmed their attendance.
Chairman, the last line of the letter says, that's the JGRA letter dated 23rd of July. On this basis, your request cannot be granted. We are in the process of seeking said advice and will provide our comments at the end of this process. So are we being told that they have gotten the advice and therefore are able to come today?
Member Brown, I am still trying to catch up where you are. Oh, okay. Fine. Because I had a one page, then, okay. Well, I have no seen it, member. What is said here. However, I have, notwithstanding what is being written, I have been advised by the clerk that their attendance is confirmed. I don't know whether it is to restate what is written, but we welcome them if and when they should appear before this committee.
To that effect, we asked the ministry if they had any record of incidents involving gas stations and so forth, which would be helpful in our discussion with them when they come. Yes. I don't know if the ministry is able to share with us such information.
Yes, Mr. Mahon, you want to respond?
Good morning. On our records, we have approximately 292 gas stations that we actively inspect. However, we have not received any cases of reportable accidents over the last 3 years from these entities. And when we say reportable accidents, we mean based on Section 21, subsection 1 of the Factories Act, which states that whenever there's an accident that results in a loss of life or a situation where a worker is not able to earn 2 days, more than 2 days of earning his wages because of an accident, those accidents should be reported to us. So those are the reportable accidents. So we have not received any based on our assessment.
Does that 3-year include this year?
Yes.
So that the accident down in Mandeville didn't happen?
Not saying that it did not happen, but based on the definition of what constitutes a factory under the Factories Act, the operations at that gas station would not be deemed as a factory operation because they were just in the business of dispensing gas. As you know, our petrol.
Sorry, isn't that what gas stations do? Dispense gas?
Yes, but some of them also do motor vehicle servicing. So the ones that do motor vehicle servicing, change oil and tire repairs, by virtue of the definition of a factory, they would fall within the ambit of the Factories Act.
So if you don't do that, you would be excluded from the Factories Act coverage?
We would not have any jurisdiction there. If you look at, I'm hoping that you have a copy of the Act with you. If you look at under section 2(6), that's subsection 1(6), and I read, any premises in which the construction, reconstruction, or repair of locomotives, vehicles, and that is where they would fall in, or other plan for the use for transport purposes is carried on as ancillary to a transport undertaking or other industrial or commercial undertaking, not being any premises used for the purpose of housing locomotives or vehicles where only cleaning, washing, running repairs or minor adjustments are carried on. And I also direct you to point 14 as well. Any premises in which mechanical power is used for the purpose of lubricating motor vehicles. So they have to have these operations for them to be deemed as factories under the Factories Act.
To the layman like me, gas stations are excluded from the Factories Act to the extent that they do not cover 6 and 14 of the Factories Act.
Yes.
And the 292 would be the total of gas stations in the country, or the total gas station covering 6 and 14 of the Factories, of Clause 2 of the Factories Act.
The total gas station that covers clauses 6 and 14 under subsection 2.
Do we have a sense of how many gas stations in totality exist in the country currently that are not, that go beyond the Factories Act?
We would not have the total figure. The figure that we have is based on our inspections, whether they apply for registration or not.
And under the Factories Act, if there's a fatality in any workplace in the country, current Factories Act, you have no obligation unless it fits squarely in the 4 walls of the Factories Act. So that we know there's a fatality down in Mandeville, that wouldn't be covered. Is what I'm asking.
Yeah.
Would it be
Well, in terms of jurisdiction based on the Factories Act, if they don't fall within that definition, we wouldn't have any jurisdiction. But suffice to say that if we are asked to assist in the investigation or expertise, we will provide that. Because it hasn't been, it is not unusual where accidents have occurred in premises that don't fall under the Factories Act, when the other agencies who have jurisdiction would ask us to attend and assist in their investigation.
And you would say, just the last one, you would say that this situation is not really acceptable in a modern health and occupational health and safety scenario.
Yes, and I agree with you totally. And that is why it is important for this legislation that we're now debating for it to pass, because we recognize that there are many gaps that exist under the regime of the Factories Act.
Thank you very much.
Yeah, no, ma'am, no problem. The last question asked by Member Brown would have been part of what I'd wanted to ask, and I'm pleased to hear the response that was given. As also thinking, though, that it has been a long time since we have just kind of accepted it as it is. I mean, we can think of one this year. I'm sure that if we were to go back in our minds a little bit further, that there would have been others. And what that would have meant, I just wanted to ask, normally how would they have been dealt with? I heard your statement that if you are asked, then you would give advice or what have you. But without being asked, are you saying that as a government, it is just allowed to pass as if it didn't happen? I'm just trying to understand how it would have operated. And we understand the importance of the bill that we are currently debating and why it is important. But I'm still just trying to understand the kind of frame of mind, mindset, and the approach to something like that.
Well, in the context of what happened down in Mandeville, we recognize that the Ministry of Energy took the lead, and there is a department that is responsible for inspecting the gas stations from the Ministry of Energy. So they have the expertise as it relates to the petroleum trade, and they were the ones who would have conducted the investigation. However, if we do have our network in terms of happenings, because many a time there may be situations that we are not aware of, it's not in the public domain, that other agencies in government will have contacted us to say that there's a concern here. We have experienced that with Nepal, we have experienced that with Ministry of Health as well. We have even the National Works Agency, the Fire Brigade. So we have this network where we have those linkages established, and depending on the nature of what has occurred, then the communications happen within government.
And then just to follow up, I'm assuming that part of the question in Member Brown's mind, and I dare to go that far, was not just simple in terms of numbers, but also in terms of what maybe are some of the lessons learned or some of the recommendations coming from examination of incidents like these and the experience of the ministry. And I was just wondering if any of that analysis or recommendation, whether it is led by your ministry or led by the Ministry of Energy, as you are suggesting, would be documented such that it could be of benefit at this point.
Well, once the normal procedure is that once accidents are investigated, there's a report. Now, coming out of the report will be recommendations, and those recommendations would be able to be accessed from the lead agency.
There's a quick one.
Yes, Mr. Skipper.
Is there a duty by the inspectors under the Current Factories Act to be proactive? Meaning, you state, for example, the gas stations, if only they are doing certain operations, they are so defined as factories, and fine, that's the law. But do you, on an annual basis, without it being reported, are you aware of it, be proactive and go to all these stations to ensure that they are so operating and not falling short according to the act, and hence you are not able to investigate them or monitor them on an annual basis? How do we ensure that all are operating and not quote-unquote factory, but you don't cater for them?
Well, in terms of our operations, every month we have a cadre of inspectors who they do itineraries. So what is the process is that the supervisors would look at our factory database to determine when last premises are inspected, not just petrol stations. But we do not wait until there's an accident or there's a complaint for us to do our regular routine inspections. So after we do these inspections, we send letters to the managers or owners with the findings and recommendations of these inspections. Then we do a follow-up visit to assess the progress of implementation of the recommendations as it relates to any remedial activity that is required.
Let me just give you a practical example. Between the area of Jamaica I am from, between Manchester and St. Elizabeth, in the last year, I know of at least 4 stations, quote-unquote gas stations, that have been newly built and in operation. Question I'm asking, if your officers observing these, can you go in without being invited and to ensure that these stations are not quote-unquote factories under the Factories Act, but really service stations, and you have no duty to so manage them? So people are not just building, because I'm a bit taken about that. What qualifies them is that they change oil and tires. And I mean, but that's a law. I'm not.
Could I just, through your chair, just interrupt my colleague. Mr. Martin, in answering Senator Skeffrey's question, could you just tell us what clause 2:12 means? It's on page 6, the second. Just let me read it here. Any premises used for the storage of gas in a gas holder having a storage capacity of not less than 5,000 cubic feet. What is meant there by a gas holder and gas? It's 2 different things. This is liquid or?
This is any substance that is in a gaseous state, not in a liquid state. So let me give you some examples. We have places that do propane and butane, LPG gases. And if you look at the units here, it said less than 5,000 cubic feet. That is not the measurement of liquid. Liquid is measured in gallons, liters, etc. But to give you an idea of how much we're speaking of, persons can relate to like a 30-pound, 100-pound cylinder. Although it's gas, they use pound. But there are conversion tables because gases have different molecular weight. Hydrogen is a very light gas, but propane is a heavier gas because it has more atoms involved. So for 5,000 cubic feet of propane, if you do the conversion tables, that's around 69 tons. Butane around 81 tons. Methane, which is a lighter gas, is 1 ton. Hydrogen gas, which is highly flammable, that's 0.01 tons. So you can appreciate the scale of what this clause, subclause in 12 here is speaking of in terms of gas, not liquid, as though we in Jamaica would call gas, which is really petrol.
I recall that in 1941, I wasn't around, but from reading, it was more mainly donkey carts that was moving around. So maybe that's why they excluded petrol stations.
All right, members, we shall now proceed to the business of clause 4. Before us are 2 documents I wish to bring to members' attention. There is the Ministry Paper 106 of 13, Implementation of Flexible Work Arrangements in Jamaica. I believe this would have been circulated to members from sometime during the course of last week, very early after our last meeting. There is also a document dated July 27th, 2020 from the Attorney General's Chambers dealing with commuting accidents. So members, I just wish for us to take note of these documents. I believe today we'll proceed with the document coming out of the Attorney General's Chambers as it touches on concerns, matters which we would have discussed during our last meeting. So members, I will now turn over to the AG's chambers for them to take us through this document that they have prepared. Yes, Mr. Basco.
Thank you, Chairman. Morning, members. At the last sitting of the Joint Secretariat, a definition of commuting accident, and I had adverted to the committee that there were duties placed on the PCBU in the bill, which to a great extent codified what the common law duties of employers were. So within that context, we had undertaken to do some research just to see if there might be a need to include treating with commuting accidents in the scheme of the Occupational Safety and Health Bill. And based on our research, I'll just start with what we're concluding, that we wouldn't advise that the committee try and codify the position of common law in relation to commuting accidents, because the position has been very varied and it's very complex, and it would be difficult to capture in legislation. Notwithstanding, based on what we've set out here, and I'll take the committee through the relevant case law if they should so desire, we are saying that the committee may wish to consider if they feel that the bill has scope for including commuting accidents.
Yes, Mr. Basco, you may proceed.
So the general approach from the case law is that for commuting accidents, there is no general liability for a person who travels to and from work, because the duty is not to travel to work, it's actually to do work when you're at the work. Notwithstanding, if you look at paragraph 2 of what I've set out, there are some general principles that take the employee outside of the general rule, and in some circumstances the employer can be found liable in commuting circumstances. So one example is where the employer obligates the employee to take a particular mode of transport. So where accidents happen, liability will accrue. But generally, based on the principles that we've set out in paragraph 2, what we're advising is that it's very difficult, and a court will always want to know all the surrounding circumstances to determine if an employee is to be considered in the course of his or her employment to determine ultimately if an employer is liable.
Members? Yes, Sergeant. Can try the other one, yes.
Morning, Chairman, members. Sorry to be late. If I could just add to what Mr. Basco said, I thought he was going to take us through all the different examples he outlined, and I'm going to ask him to do that as well.
Yes.
But what it will show is that we're not just saying that trying to fix the position in law can work against either side. It can work against the employer and it can work against the employee. Because what these examples show is that in different circumstances, the court has found that it was the employer's obligation, again looking at all the circumstances, but the case law has been developing over time. Perhaps not very quickly, but it still has been developing. If you put something in law, it is now going to make the case there. It's going to leave it there. It's going to be fixed. Whereas the case law seems to always be speaking to us, looking at different circumstances, and to me, sometimes doing what is fair and right and equitable in the circumstances. So that would be part of the reason we would caution against trying to codify the common law at this time. But again, it's always left to the members to determine how you proceed. But I'm just going to ask Mr. Basco to just take us through all the different examples so it would give the committee members a better idea of the way the court has ruled in several situations.
Yes, I share that view too. Mr. Basco, yes.
Okay, Chairman. So it's at paragraph 2 where we had indicated what the principles are. And the first principle essentially provides that an employee traveling from his ordinary residence to his regular place of work, whatever the means of transport, and even if it is provided by the employer, is not on duty and is not acting in the course of employment, which was consistent with what I said the general approach has been. But if the employer obligates, either through the contract of service or otherwise, that the employer's transport is to be used, then in those circumstances, what we have found is that the court is willing to view the employer as being in the course of his employment. So traveling in the employer's time between workplaces is another situation in which the court has leaned in favor of finding the employee to be in his course of employment. So for example, if you work in a particular industry and your employer sends you to another place, it's not your actual workplace, but to do a certain type of work, and you're injured during the course of that, then the court has found that you're in the course of your employment. Receipt of wages usually indicates that you're in the course of your employment as well. So in this very same case, the Smith case, what you had was they worked in a particular industry that dealt with insulation. And so the employer paid the employees to travel to as well as from that particular work site. So because they were actually paid to go to those places, the court viewed them as being in the course of their employment. An employee traveling in the employer's time from his ordinary residence to a workplace other than his regular workplace or to the scene of an emergency will be acting in the course of his employment. So you can readily appreciate, for example, you get a call, you may be in a service industry, you get a call from the employer before you report to work to say, don't come into work, go to place X. In those circumstances, what the court is finding is that your work has actually begun. So even though you're driving to another place, you're driving in pursuance of what your actual duty as an employee was. And then the fifth point was that a deviation from or interruption of a journey undertaken in the course of employment, unless the deviation or interruption is merely incidental, which could be, for example, stopping off to get lunch, will for the time being take the employee out of the course of his employment. So it has to be something in the nature of a significant deviation from what you were otherwise employed to do. But things that are merely incidental, if you had to go to the bathroom, for example, there's case law that still found the employee to be in the course of their employment. And return journeys are to be treated on the same footing as outward journeys. So unless the committee has any questions regarding the common law approach to commuting accidents, I think that would be the extent of what the Chambers has to say.
Thank you, Mr. Basco. Members? Member Brown?
I'm happy for the case. But I just hear the sergeant's point and I'm moved by it. But I just want to remind that, as she did, that the common law is not, that we can determine statutory legislation, whether we incorporate the common law or we modify it. But in the current situation, I don't want anything going back to the chambers in which it is felt that the parliamentarians, like judges, are not following the law.
It's not for here. All right, so I believe that I believe that the advice as provided by the Attorney General's Chambers is sufficient to guide this committee. And in keeping with the position that the ministry has put forward, I believe that this opinion has certainly guided us. So we shall proceed with going back to our matrix. Yeah, man, we are
Just to be clear, Chairman.
yes.
And I just want Mr. Basco to confirm. This is a House of Lords decision, not an industrial dispute tribunal of Jamaica decision. So it's cool that it comes from way up in England that rules us, where decisions of the local tribunal does. The tribunal could use this. Am I correct?
Look at paragraph 6, where we speak of a Supreme Court decision.
The black people decision down here? I understand. I appreciate that. But they apply the principle in Smith so that the tribunal could apply. Because we're going to, when we have a tribunal, it could take into account these principles of the, I'm missing carbon. It could take into account these principles in guiding a local IDT decision or whatever the tribunal name.
So I would consider it to be persuasive authority.
It will be persuasive authority. Good, thanks, sir.
Yes. Mrs. Seeley Brown, you wish to say something?
I'm just confirming that we're deleting the definition of commuting accidents, Chair.
Ministry, was that the recommendation? Mrs. Benny Campbell, any comments?
Well, all we were trying to do is we were actually trying to refine the definition in terms of records. We were not trying to attract liability, but in terms of records.
But, Chairman, I push strongly for it, but I agree that all the bill does is for the purpose of record. But I'm thankful to the Attorney General's chambers for saying bill or no bill, there is an element of telecommuting that we should take note of, and that in taking it out of the bill, we are doing so conscious that at common law, which is Mr. Bosco's point and the AG's point, AG's department point, that the workers of Jamaica can benefit and be covered in going to and from accident in certain circumstances, as outlined in the Smith versus stage, not stage carriage.
Yes, Member Brown. So, Mrs. Benny Campbell, you have heard, I think what Mrs. Seeley Brown is querying is whether or not, whether we should keep a definition for commuting accident. Yes.
We're discussing, we think we could delete it, but we need to discuss it further as a team, because what we have here, it needs to be amended, because the committee did not agree with the definition.
Mrs. Seeley Brown,
Yeah.
Even in your, in compiling your statistical data, you can still be guided by the common law. Yeah, I don't think we should confuse the issue by putting a definition in the bill. Respectfully, Chair.
Yes, so we're not opposed to deleting it, especially if it's going to cause confusion, because we really want it for statistics and data. So.
Members?
I'm just, take the recommendation, but I mean, if you want statistics, you don't need a clause to be in the bill to do that. That to me, that is more of an administrative nature. So I don't understand the confusion. Why would you need it in the bill to prevent confusion? I just want clarity. Because to me, if you want statistics, that's an administrative task. The management can set department and persons to gather that data, because having it in the bill is of no consequence in my mind if it's just statistics. Because if you don't get the statistics, who will be liable? And I think that's the purpose of law, to hold people accountable.
Ms. Benny Campbell, I know something was said, Member Skeffrey, about the ILO. I do not know if... Yes, Mrs. Benny Campbell.
Yes, the fourth schedule deals with contents of systems for recording and notification. So it gives some responsibility for recording certain information, including occupational accidents, occupational diseases, and it includes commuting accidents. So it's we have a provision in the fourth schedule also.
Okay, but where in the main text is there a reference to commuting accident? Or it's just the schedule?
in 133(3)(a), it deals with the recording and notification in accordance with the fourth schedule of occupational. It points you to the fourth schedule: occupational diseases, accidents, diseases, dangerous occurrences, commuting accidents. So it's still linking to the recording and notification and statistics.
Yes, Mrs. Seeley Brown.
Remember, we discussed that last week, Chair. So what we're saying is, even if you don't define it and you depend on the principles in the common law and you even want to go outside of that, that's fine. But I think to define it in the way that we're doing here will create somewhat of a confusion. And I think we should delete. I'm strongly recommending that we delete it.
Delete commuting, the definition from clause 4. All right. Yes, Member Brown.
Not opposed. Just I hope that the report of this committee to the rest of the Parliament will say that your committee consider the issue of telecommuting, took a decision to delete it, and in taking that decision we were influenced by the existence of common law rules which now govern that, because I think it's important to alert the Parliament
Very well.
as a whole of the existence of these common law rules, for which we thank the Attorney General's chamber.
Certainly, Member Brown, that note has been duly taken. Welcome.
So, Chair, the
yes.
Commuting accident is also in the definition of occupational accident. Page 11 of the bill.
Mrs. Seeley Brown? It appears wide enough to include the common law. Yes.
Yeah, we're just having a discussion because occupational accident is even wider. It just includes commuting accident. So we can take it out from there, but I need to see how we use that term in the bill before we further advise.
So, but you still maintain the position that we should delete. Okay, very well. Member Gill, you wish to? Yes.
Chairman, my apologies for being late, sir. It's most unusual for me, but it's that type of a Monday morning. I want to refer to what Senator Brown had indicated around the committee deliberating on commuting accident. And I would not have wanted at least the report not to have reflected in some way the deliberations or discussions around this particular critical matter. But now that we have been pointed to the definition of occupational accident, which refers also to commuting accident, and I agree with Mrs. Seeley Brown, we would want for it to be at least see how it reflects in the legislation, and if it's not reflected, we may have to find a way to include how it is used, because I'm of the strong view that this is an area that has to be protected somewhere in the reference of the legislation itself.
And have you, remember, I know you came a few minutes ago, but have you had sight of the...
Yeah, I have sight of it. Yeah,
okay, very well. Yes, Mrs. Bennett Campbell?
I am not sure if we had page 6 and 7. On page 7, the minister...
Of page 6 and 7 of what?
Of the matrix.
Okay, very well.
On page 7, Joshua, the second paragraph, The ministry had actually asked that the words "and includes a commuting accident" should be deleted to avoid confusion from definition of occupation.
Okay. Of the matrix, page 7.
Yeah, I don't know if it's that we hadn't
On the
discussed it.
MLSS response from Joshua, right there.
We started with OPC, clarification between commuting and occupational accident. And then we had actually asked to avoid confusion for the commuting accident to be removed from the definition.
Okay, very well. Mrs. Seeley Brown, any comment? Yes. Okay, fine. So we had already, what?
Sure if that part of the response was actually discussed in the meeting or not, because
Okay,
I don't see
very
any
well.
notes.
So we'll take
beside
both of them
because we had something.
at this point. So members, what is before us is for the deletion of a definition of commuting accident, and also for the modification of the definition of occupational accident by deleting the words commuting accident from that definition. Do we agree, members? Very well. So we shall now proceed, Ministry. We'll pick up from where we, Mr. Simmons.
Right,
Yes. Yes.
Sorry to break up the flow, but could you give the ministry a chance to look more at it to see, regarding the definition of commuting accident, to see how it will actually be used in the bill? Because I can foresee a possibility that if the term commuting accident is used in the bill, persons may still want to know what you mean by that phrase. It may be that a fairly innocuous definition could be used, one that doesn't run contrary to the common law at all. But just don't take, I would advise not to take decisions to delete it outright. So I'm not disagreeing with my learned friend, but I'm not totally agreeing with her either.
Yes. Yeah.
I just think that an innocuous definition of commuting accident could be found.
Yes. Any comments, Aljan? Mrs. Seeley, bro? Yes.
An innocuous definition would still fix the law here. So the point is, it would take you outside of the remit of common law. That's the point. So once you put something in your law, that is what you mean it. That is what you're saying. The legislature wants you to interpret commuting accident. Any definition you put in is going to fix the law as of whichever date this act comes into effect. So I'm just saying that is what you would have to take into account if you do something like that. And so if there is any further development in the case law, it will not be reflected. It will not be reflected in your bill. And so that is what I'm saying that you would have to take into consideration. And then to be able to find an appropriate definition will be very challenging. I mean, we have just outlined some of the circumstances in which the courts have found it, whether to be the employer's liability or the employee's liability. I'm not sure how easy it will be to do a definition. What you're going to do, list some, and then what would be your sweeping upwards? I'm not sure. Because we have to be very careful when it comes on to these matters of tort. When you're looking at who bears liability in different situations. I'm just saying it's not an easy thing to do when you're trying to codify common law. Normally we try to codify it when we know that there is a pretty certain position that won't necessarily change and has not really been changing over time, but it's not something that we really encourage. But again, it's still up for consideration. So.
Yes, Mr. Simmons.
All right. I'm just taking the Ministry of Labor's point that they made, that it's not for attaching liability to any employer. It's strictly for reporting purposes. So if you can clarify why the ministry wanted to include commuting accidents, the definition that it would include wouldn't be changing the common law position in any way. It's strictly what they want to capture for reporting purposes. So if you wanted to say commuting accident means traveling in the course of the employment, to me that is a fairly innocuous way of defining it. It wouldn't be changing the common law anyway, because even from the, at least what I gather from the advice given by the AG, in each of these cases, the court has determined the commuting accident to be in the course of the employment. So as long as the commuting accident, but I don't know what is a policy position right now of the ministry. But I'm saying if it is that you're going to use the phrase commuting accident, a question can be raised in the future as to what you mean by a commuting accident. So if it is that we want to use another phrase to capture for the purpose of statistics, I'm fine with that. But I think they just need to look back at it some more.
Mr. Sin?
Can I just add though, when it comes on to collecting statistical data, why would the ministry want to confine itself or restrict itself when you are looking at statistical data and how you collect it and what you're collecting it for? Your purpose will change over time. Look at most other laws. We usually just give the power to collect statistical data. You don't try to confine it in any specific way because your purpose will change over time. And this is to be a law that hopefully, I mean, it is not just, when you legislate for a long time. And even though, yes, you're going to be reviewing this law 5 years after the first commencement date, but I don't know if you want to put things in now that you know will confine or restrict the operation of that provision, especially since this is not the way we usually deal with statistical data in other pieces of legislation. Usually make it way more flexible and very open-ended.
Chairman, isn't it sufficient to say relevant data that covers it in perpetuity? Because we don't have to go into the specifics. It's for now the authority to look to see what is relevant. It may be tele accident today, it may be near misses tomorrow, so that if we give them the task of collecting relevant data, the relevant is for them to decide. So we don't need to go into the specific. I agree with the submission thing. But I just, and also, Mr. Simmons, the ministry hasn't come to us with any specific policy and accident and benefits or protection that flows from that. It is the troublemakers in the committee who have been pushing for the recognition of this, and we are really grateful for the work done by the Attorney General's Department, Mr. Basco and the others, led by the Surgeon, who has said to us, there is in fact a set of common law principles that exist, and I think we have agreed to say in our report that your committee recognized the existence of these common law principles. And that, I think, takes us far, because the ministry is not proposing any such thing. This is for the troublemakers who see people suffering to point them to some possibilities under the common law.
Yes, Soldier.
Generally, when it comes on to statistical data, the only thing we would require, and that's because of our right to privacy provision, is that the data should be anonymized. So normally, when we are looking at making provisions for statistical data, you don't want it to point to any one specific person. You don't want to do anything that would necessarily breach or infringe a privacy right. So generally, this is why if we're going to provide for it, it's usually just to ensure that it's anonymized to a general extent.
So what you're in fact saying is that, Soljan, what you're in fact saying is that if, no, that's all right. The communicating between you two is sometimes very helpful. What you're in fact saying to us is that if we're going to ascribe the collection of data, it must be for that specific purpose and not to be attached to anything else or result in anything else. And I agree with you if it's going to be that specific. But Chair, having looked at what these areas that has defined the principle governing commuting accidents, they are really clear in our mind, you know. And for once, I can find myself belonging to a group of troublemakers. But this brings some clarity to it, and it has been defined in such a way that it really outlines the practical situations that may be applicable under the different areas of commuting accident. So I'm prepared as a member to go along with this guidance.
Very well. Minister, any comments before proceeding? Yes.
Comments you made as before, we were in support of taking out the term.
Okay, very well. Members have voted already. May we now proceed? Mr. Mohan, you can just pick up from where we left off, or I think we were looking at on page 10 of the matrix, terms used but not defined in the bill. I think we stopped at the definition of a factory as put forward by the ministry, and certain recommendations were put forward. So I think we are to pick up thereafter. Mr. Mohan.
So the ministry has taken the suggestions of the committee and members that we need to revise this definition of factory to make it much shorter. So we have started the process, and we will submit to the committee at another day the finalized definition of a factory from the ministry's perspective. So we are actually now at terms of use but not defined in the bill. 7, relevant worker.
Don't move so quick.
Yes,
in regards for the discussion we had this morning in respect to service station, gas stations.
Yes.
I had hope when the ministry worked through its definition.
Yes.
That we capture everything.
Yes.
So that we don't get into a situation where it is the mechanical.
We use in
and not the
workplace now,
dispensing
Member
of the
Brown.
gas.
We use in workplace now. The bill will apply to all workplaces.
Yeah.
So I think that should cover the gas station.
Yeah.
Yes.
But then we're going to insert a factory.
Oh, you want to? Okay.
So I'm just concerned that that factory definition doesn't undermine all workplace. Doesn't undermine all workplace. Because this month was glaring to me. I mean, let me put on record here. That accident at the school, well, Villa Road School, all while this committee sitting, the transferring of the gas to the kitchen doesn't seem to be captured under factories or any such thing. And since it's not a premises where the gas is stored, since it's transient, how do we make sure places and situations like that, scenarios like that, are captured in the bill we're putting? I think, was there a fatality there as well? So now I begin to, when I read about the fatalities reported by the Ministry of Labor, I must discount them for not falling under the Factories Act, so they didn't capture this one in Mandeville, or the 2 in Mandeville and so forth. So there were more people might have died by accidents at the workplace, but they're not captured by the stats from the Ministry of Labor. I think that's important for us to note, because this is why this bill is so important.
Mr. Chair, Senator Brown raised a point, and
Yes.
it got me thinking. If this bill is applicable or will be applicable to all workplaces, why we want a specific definition of factory? I just want to understand.
Very good question. Mr. Mohan?
Well,
What is defined as a workplace?
Yes,
All right.
but the transition, but Mr. Mohan will speak.
just to, let me respond to Member Brown first. The expanded definition of workplace as set out in the bill as we have before us, it would ensure that even for the place where we had that accident at the school, that would be considered those workers' workplace. So they would also be covered under this bill, given the fact that although they are not at probably the head office where they would have picked up the LPG that they were transporting to dispense at the school, by virtue of them being there and during the course of work, it is their workplace, so that would have been captured in terms of statistics. The other question was?
The question?
No, that's in this bill. I'm talking about the current data because your reference point now is the Factories Act.
Well, not just the Factories Act, because there's also, well, the Factories Act and its regulation, because you have the factories regulations, you have the regulations that govern the construction, you have the docks and the ships.
But the regulations
it
can't
would not
do more than the Act has said, you know.
Yes, but in terms of the jurisdiction, you're right, we're not covering all workplaces. So the statistics that you will see us put out from the ministry is not covering all workplaces where fatalities may occur. But under this bill, it will.
Mr. Mann, I accept that under this bill, there's a will. I'm talking about the current data that we receive, and that will drive our views towards this bill from the Ministry of Labor, pre this bill, that data may not, because of what was said earlier. So when I read and said, the Honorable Minister made a report to the Parliament, a big document, I haven't read it yet. We got it in the Senate on Friday. So that would have occupational health and safety issue, and it may report on the number of deaths, for example. And what I'm saying is that based on what we learned this morning, and I don't know when the accident happened, Skip, it might not have been captured in the data.
That is correct.
And so, in reading that data, that past data, and previous data, we must take into account that it may not be reflective of all the accidents.
That is correct.
And I say this, Chairman, because earlier we had asked about accidents.
Yes.
And the number of accidents to inform our discussion. And I'm discovering that that is the information we got, which may have very well be short.
Yes. Member Skeffrey, you wish to?
That's the question. I say, given this current bill that we are debating, we capture all workplaces. So why we want a specific definition of a factory in it?
So, as you recall, around 2 sittings ago, we mentioned the whole aspect of registration. And even under the current regime of the Factories Act, there's a requirement for registration. What we intend to do is that the registration will continue that regime under this new bill, but based on the type of activity, they will have different periods for registration. Currently, the period for factories registration is 3 years. But for offices which don't fall under the Factories Act, but now fall under this bill, there will be a requirement for registration as well. So the period for the registration of the office would be different from the period for the registration of the factory.
Clear, sir.
Yes, Member Gill, I recognize you.
So are you saying to us that the expansive definition for factories that you already have, you will provide us later on an expansive definition for offices and agricultural areas or any other undertaking that is not so, that will give a similar approach, like how you have it here for factories? Are you saying that to us? That's the first question. Mm-hmm. And the second question is that, are you saying to us that the registration for the offices will come later on?
All right, to address your first question,
Yes, Mr.
we have had expanded definitions of agricultural undertaking. We already had a discussion around that in previous sittings. Now, in terms of factory, we would have a definition for factory. We would also have a definition for offices. So as we start going through, you will see the definitions coming on stream. As it relates to registration, that is something that we will be coming back to the committee with to finalize, and we will be looking at it from the different type of establishments. The registration for offices will be also a part of the regime. We spoke about the phase implementation. They would be required to register. It's just that the period would be different. So we have the different categories of establishments that are going to be registered, but the registration is going to be for different periods.
Chairman, my concern is that under the rubric of factories, you have this expanded definition, but you have some other industries that employs potentially a great number of workers. And I talk about the BPO, the tourism industry that employs a vast number of workers, and I wouldn't want it to be felt that we'd have gone through this very detailed, deliberate approach towards coming up with a piece of legislation that should really protect workplace and workers. And some people believe that they are exempted by way of not being governed under this detailed type of definition. And so if it's a situation where we have to wait for an undefined period for that to happen, then it's cause for concern, certainly on my part.
Just to understand you, Member Gill, are you speaking about the registration? Because clearly, as Mr. Mahan would have indicated, the bill is now broader in its application than that which was previously provided under the Factories Act. So you have moved away from the factories to now include the service sector like the BPOs and the hotels that you have spoken about. I think what he has indicated is that where registration is concerned, the committee would have had preliminary discussions in terms of a phased implementation, and there may also be a phased registration process depending on the sector or the branch of economic activity. That is my understanding, but you may want to defer the discussion until the ministry comes back with registration and setting out the phased proposal as would have been contemplated by the ministry.
Well, it's a question of when they will come back to us, you know. That's one. And also, in my mind, in terms of the protection, it's not only the question of registration, but also inspections that may have to take place.
Yes.
So I'm just trying to understand the argument. So you will have a broad definition for workplace, and then you will have a definition for all the subsets that you will so register / inspect. Is that the intention? And what if you don't define a subset? What can I say? Boy, you don't capture me. I just want to be clear.
Yes, I have heard you, Mr. Silibro. Mr. Mahan?
Yeah, so the bill is going to be looking at and capturing workers in all workplaces and providing the protection. However, for the purposes of registration, right, we are going to be categorizing we will not be inspecting premises by virtue of registration alone. We will be inspecting them periodically. So even now under the Factories Act, registration is 3 years. Within that 3 years, we might inspect that place 7 times, 8 times, 10 times. So registration should not be confused with inspections. It is just that for the purposes of registration, we will do an inspection. Because as you would, if you can jog your mind and remember, we plan to use the information from registration to have it on our website. So persons can now look on this website and see that these places, they have met a minimum standard when it comes on to safety and health in there. So if you're going to do business with them, you know that you as a businessman engage in a contractor to come and do some work. You can look on the website and say, oh, this person is registered, so more than likely they have met a minimum standard of safety. So when they come to do work with you, you have some assurance that, you know, they will have a safe system of work.
Chair, so we'll get the registration, but just for my understanding, because I try to be practical.
Yes.
The registration, if I don't register, what does that mean?
If you are required to register and you don't register, then you would have been contravening.
For some workplace, registration be mandatory for some and not for some, and why, if that is so?
Well, in terms of registration, we can't register every single workplace because it would require an inspection.
So what's the advantage of registration then?
So what happened is that, especially for the ones which the activities may be deemed as high risk, based on the nature of processes that are being carried out in there. So if you can think about, for example, a factory, if you think about a construction site, a dock, these are operations that have high risk of injury to workers based on the hazards that are present. But nevertheless, for those which are more on the lower risk side, like offices, you still want to, based on the size, as Member Gale was speaking about, you still want to at least hold them to that standard.
I understand that, you know.
Yes.
But the bill gives you the authority to inspect all workplaces. Shouldn't be in our a feature of how I implement my operational plan. That I know these are all high risk.
Yes.
If I don't register, you still can't come check me, don't it?
Yes.
So what's the advantage of registering?
Before you come in, Mr. Mann, I think, Member Skeffrey, there is a provision in the bill that deals with registration of establishments, I think. Yes.
But knowing about the definition is important.
So registration will only apply to establishments. So something like the dwelling house, you would not expect the dwelling house to be registered.
Mr. Chair, I understand all that, you know.
Yes.
But I just want to understand if the implementers of the law has the authority to check registered and unregistered. What's the advantage to me as the employer to register? Because what you want to check is to ensure that safety standards are
maintained,
whether I register or not.
Very well.
Or is it that I have to pay a fee to register, so it's a part of the council fund?
Very well. Mr. Mann.
Very well to that.
Right. Let me just remind you of a submission that we did that just brought it up as to the rationale for registration. And we had some healthy discussions around it. And we looked at it from, I mentioned one already, to promote higher standards of occupational safety and health by creating public awareness through publishing on our website a list of registered establishments which have attained a minimum level of safety and health in their operations. And we mentioned about trying to have a standard similar to like how you have good manufacturing practices, HACCP certification. We want to encourage persons to recognize that there's an opportunity that exists in that regard. To assist persons who are getting information in regards to safety and health profile of establishments who will potentially engage to perform an activity in the workplace. Because the Act Bill sets out the obligation of the person conducting the business or undertaking to ensure a safe and healthy workplace, which extends to the persons who they engage to do work on their premises. Another one is that The particulars declared by the applicant during the registration process are useful to facilitate monitoring, enforcement, and compliance. For example, determining the person against whom an enforcement or court sanction should be directed. The other point as well is that the particulars declared by the applicant will assist the OSH officer to prepare himself with the requisite resources that may be required prior to conducting an inspection for registration or renewal. For example, the name and the location of the premises he must visit, the person who has management control of the premises, personal protective equipment that the OSH officer will require to protect himself, to do research on specific process, material, or equipment that is used at the premises so that he is familiar with the hazards and the necessary safeguards required. So you can see that the registration serves not just the person who is conducting the business or undertaking, but even the authority to prepare itself when it's going out there to be effective in its carrying out its mandate.
Mrs. Sealy Brown?
I just wanted to go back before I deal with this point to looking at the definition of factories. And I'm thinking that we should just square bracket it for now and come back, because we may, based on what Senator Gale was saying about the fact that it is wider than factories, because the Factories Act dealt with other aspects that may be included here as workplaces. We may not need to define it. Maybe for regulation purposes we may, but right now we may not need to define it. The second point is, Chair, I think when we were having discussions in relation to Part 4, I think we said we were going to modify it to deal more carefully with...
Part 4 deals with what?
Part 4 deals with registration of businesses,
okay.
And to deal more carefully with non-registration, because as the bill now stands, the principle is that you must register. And in subclause 17, it gives the minister power to exempt from registration. So the overlying principle is that everybody must be registered. But because of the discussions we had before with respect to domestic households and all of that, I think we had sorted this, we decided we were going to tweak this provision to assist in the issue that Senator Skeffrey raised with respect to the exempt categories under subclause 17 of clause 40. We may have to say, for the avoidance of doubt, not because you are exempted, you don't have to comply with the provision of the Act, but you may have to make that clear. If we are not changing the mischief, yes, which I think is we had come to some, I think we had come to some decision as to how we would have to redraft Part 4 to deal with, because we were saying that it's not every single business. The capacity of the department to register every single business or the authority might be problematic. So I think when we get there, that is the discussion that we would have to have, and then state categorically that even though you are exempted from registration, it doesn't mean that they can't inspect, and you won't be liable, and you must still comply with the provisions of the Act.
Mrs. Barry Campbell? Yes.
Yes, Minister, and I think the ministry had reverted on about 2 occasions with our amendments to clause 40, and the committee had deliberated, and there are still some minor amendments they sent us back to do. So we'll revisit at that stage. But we did come with a whole change of the provisions that are contained in the bill in relation to 40, and I think we presented on 2 occasions.
Okay.
But there's still some work for us to come back to that the committee sent us with.
Chair.
Yes, member.
I am with the Parliamentary Council team. But could we hear from the employers whether or not they have any concern with this issue? Because the exemption or non-exemption or the inclusion of everybody but would be something that I think could have been of interest to them, and I'd love to hear their views, which is why we had invited them here too. Maybe a deal moment.
They are inviting you to speak. Yes.
Yes, thank you, Minister. I left the room for a few minutes. We're still on the AGC document, no?
No.
We have moved on from there, right?
Yes. Yeah. We are on the matrix. Yes, dealing with clause 4 and the different terms and the definitions. We were looking at the definition of factories. So there was a discussion as to whether or not a specific definition is to be included for factories, having regards to the fact that the bill will apply to workplaces generally.
Minister, on that matter, I'm going to have to refer to one of our subject matter experts to give a view, so I don't want to give a view right this minute.
Yes,
Right.
and we are coming back to the point of import, which I think Member Brown was referring to, and that is the duty to register and exemptions that may flow from that specific provision. So this is a conversation we can pick up when we get to the discussion of registration of establishments.
Okay, but if you don't mind, Minister, I'd like to raise a point
Yes.
that is a gray area that I've been looking for somewhere to, within all this, that we could speak to this if you decide and the committee decides we should speak to it. And it has to do with, it's closely related to occupational safety within the context of what the AGC wrote. And it's with this preponderance of working remotely from home. And we don't know how long that's going to continue, because if COVID decreases, the quantum of that might decrease. But the concept of someone working remotely from home and having an accident, it's a matter I've raised before in different fora. It's a gray area about the liability. In that scenario, someone working remotely, speaking to a customer on the phone and walking from the kitchen to the living room, slip and fall. I mean, it may not be feasible to really capture who's liable in that scenario, but it's a point that weighs heavily on our mind. And that's the point I want to raise, Minister.
What I will say, member, workplace and the definition of what constitutes a workplace, I'm sure the members will, the discussion certainly will go there. You also at that time will be invited to participate. But as it now stands, we are going through the terms on an alphabetical, in an alphabetical order. So I guess once we get to workplace, the definition of workplace, then those discussions can be had at that time.
In the interim, Chair, I don't
Yes.
know if the employees have benefited from the document that Mr. Basco did from the AGC, because that may be helpful in if traveling to and from work is what it deals with. It may very well be helpful with working in a remote location. So that, I don't know if he has been given a copy, but it will be helpful so that
I'm
himself
almost certain he has a copy, but I think, Member Brown, just to...
The one from the Attorney General's chamber. That would be helpful along the way. We're sending in a bill, though.
All right, so we shall now proceed, Minister. Yes.
Right, so under the terms used but not defined in the bill, relevant worker, based on previous sittings where we had decided to remove certain clauses from the bill.
Do advise us of the page. I think you're on page 14.
Yes, we are on page 14 now. Over by the ministry's response, C7, and we have no longer relevant there. It is because relevant worker will not be used throughout the bill. Clauses 89, clauses 115, 116, and 117, where it appeared. Under Part 7, workplace entry by labor officers, we had made a submission for those clauses to be removed. So by virtue of that, the term relevant worker is no longer relevant in the bill.
So we, members, yes, it is a little, where the definition of factory stops, 20,
So we're at page 14
23, then where you
of
have
the
C there,
matrix.
that's where he is, you know, dealing with the relevant worker. And he's asking that that be removed. Yes. So I proceed now.
So the ministry is also recommending that some other terms used in the bill which should now be changed, which should now be removed because of policy changes. Advisory council, director, discrimination, discriminatory conduct, labor officer, prohibited reason, technical advisory committee, and work group.
Yes, Mrs. Sullivan.
I think it was mentioned when we were looking at these same terms that there was a note to delete part 6 of the bill, which deals with discriminatory, coercive and misleading conduct. My note doesn't say that. My note says it was supposed to have been redrafted. So the whole part that deals with discriminatory conduct.
Mrs. Benningham.
Camille, yeah.
Yes, we had, based on recommendation we got from the committee, we were told to look at framing it in the context of reprisals. So I think the summary decisions of that the Parliament put out 1 to 118, that document sets out all we had done in relation to reprisals. So we're taking out the context of discriminatory conduct, and I know we presented it 2 times at the committee in relation to reprisals being the language. So I guess we'll have to revisit those minutes and the summary of decisions because
Yes, any?
Chair,
Yes, Member Brown.
I don't have a problem with taking out the words here, but this number 3 and 4, discrimination, discriminatory conduct, so long as we are going to have in the bill something about HIV and our attitude to the HIV issues. I think we'd agree on that, but I don't want to buy a green here and then find that in default that gets.
Mrs. Benningham, you wish to comment? Yes, very well.
until everybody has gotten a chance to look back at the minutes and the summary of decisions in relation to reprisals,
Yes.
we will have to leave discriminatory conduct until the committee also refreshes its memory.
Yes.
So discriminatory conduct we will leave for now until the committee, everybody has looked back at the minutes and the summary of decisions 1 to 118.
Okay, very well. So members were clear on that? All right, very well. We proceed, Mr. Mohan.
So following on that as well, the Legal Reform Department had raised some concerns which I think we have addressed already in terms of critical substance, where we had agreed to have this term deleted. So we're now at dangerous incident. Legal reform raises that dangerous incident and dangerous occurrence, the definitions of these 2 terms appear to be overlap and can be merged. Do we need both? See sections 133(3)(a), clause 221, and the 4th schedule. So this suggestion is supported by the ministry in that we don't need these 2 terms. The ministry is not opposed to having the definitions being merged. So we will work with Ms. Celia Brown, the drafter, to see how we can merge these two terms into one.
Mrs. Celia Brown?
Yeah, we can, Chair. I'm still looking at it and I'm thinking that when I look at clause 37, that it may cover even paragraph A of the definition of dangerous occurrence, so we may not even have to add that limb, but I would examine it further to see. But I think it can definitely be merged.
And in that regard, if it is merged, we would only be defining one term, which may be dangerous.
Dangerous incident, because that is what, yes.
Okay.
That's what, yeah, clause 37.
Yes. Yes. But you could use a mic, remember? Yeah.
I was really wondering what was meant as dangerous occurrence, because occurrence in my mind suggests a repeat of an incident. Yeah, it wasn't clear in my mind as to why you would have wanted to reflect a dangerous occurrence. I can understand the incident, which would be categorized as a near miss, but ought to be reported and investigated. But the occurrence now, I wasn't clear in terms of the objective of having dangerous occurrance.
Chair,
Yes.
even based on what the member is saying, even though it's defined, it does not even imply that, because it takes you straight to the definition of dangerous incident, and then before that it speaks to just a readily identifiable event, not an occurring or repeated event with potential to cause an injury or disease to persons at work or to that's why I'm saying that I think it can even be covered by just saying dangerous incident has a meaning assigned to it in section 37, because there's nothing in that definition of occurrence that says that it is a repeated incident or anything like that. If that is the intention, it's not clear from so what we can do, Chair, we can also square bracket it if you wish, and then when we get to how it's used, we can see if we need to define it rather than, spend time on it now.
Yes. Ministry, any further comments?
We take the advice of our partner, Office of the Chief Parliamentary Councils.
So we will proceed then?
Right.
Um,
So we are now at design.
yes.
Legal Reform Department.
So it is before you proceed, so Mrs. Celia Brown, you will come back to us on this.
Yes, Chair,
just
once
for
we
the
see
note.
how,
Yes.
or if dangerous occurrence is used, yes.
Very well. Yes, Mr. Mahan.
Design, Legal Reform Department. Design as mentioned at paragraph 2. Consider replacing the word plant with another word or phrase that is more readily understood. This definition can also be reformulated and shortened. The ministry response. A plant is further defined in the OSH bill to include any machinery, vehicle, equipment, personal protective equipment, appliance, container, implement, or tool. Any component of any of these things and anything fitted or connected to any of these things. We believe that defining the word plant within clause 4 gives sufficient clarity. Not sure if that addresses Mr. Simmons' concern.
Yes, Mr. Simmons.
Mr. Chair, right. My problem is not right. The problem really stems from the fact that the word plant, the use of the word plant within the bill is not consistent. Plant, as defined in the bill, means machinery, but there are other contexts in the bill where plant actually means something. It actually means plant as we know it, something growing out of the ground with roots. If you define it in the bill as plant, it means anywhere you see the word plant, it must mean machinery. So maybe you need to add something where, unless the context, otherwise, something like that needs to be added to definition.
Can you direct us to that section?
Sorry.
Dave? Definition, section 4, man. Design, he's looking at that.
Page 3.
Mrs. Celia Brown, you may want to assist us here.
I'm thinking, Chair, because because we have dealt with that in clause 4, where we say
Okay, all right. Fine.
right, unless the context otherwise requires. So where it is not meant to mean plant as defined here, we will have to define it. Okay?
Yes.
Yes, Sergeant.
I have a different issue. Now I know we can define terms to mean different things in different acts, but I'm looking at design, and you know we recently passed the Patents and Design Act, and we now have a big regime about designs, which is in the Patents and Designs Act, to implement international obligations. So I'm just wondering if the ministry took that into account. So I understand that we may not want to be dealing, you don't always have to have consistency with definitions and terms in different laws because of the context. However, I'm just, again, still wondering if the ministry took that into account since we were implementing international obligations in the Patents and Designs Act. Just a question, because I noticed this is dealing with redesign, modification of a design. So just a query.
Mrs. Bennett Campbell, do you have a comment?
No, we did not take it into consideration.
Okay. But that is something that you will examine? Okay.
Chairman, since the ministry didn't ask it, I want to ask of our friends in the AGC department, do we have a preference for consistency and so forth?
It really just depends on what the intent of this bill is, how far they want to take it in terms of the meaning of design and the types of, I don't want to use that word, design, what they want to take into consideration. And again, I was just looking back to see how we were using the term design in the law. So I really can't answer the question right now. We ourselves would have to also kind of undertake a little research into it to see whether, and we can always liaise with the ministry to give our own opinion on the matter. But they would have to also undertake it from a technical perspective as well.
Very well. You want to just go through the comments from the Combined Disabilities Association?
Right. The design is to be redefined with reference to the building code. Well, it's not building code, the Building Act 2018, and the concept of universal design to include design of products, environments, programs, and services to be usable by all people to the greatest extent possible without need for adaptation or specialized design. And this is in relation to clause 22, subclause 2. So we are of the view that the usage of design in the bill, as stated, is in relation to a plant, substance, or structure. The Building Act of 2018 does not define design and thus could not be used as a reference. It should also be noted that Section 3 of the said Act sets out the Act's objectives, which are different from the objectives of the USH Act. The objectives are merely connected to building structures, components, construction methods, standards, codes, and enhanced amenities. The concept of universal design contemplates the principle of accessibility in design, while Clause 22, Subclause 2, contemplates the principle of safety and health in design. So it is our intent to place focus on the principle of safety and health in design, which applies to all workers in this bill.
Yes. Yes. You want to use your mic?
So I just want to know, when a worker says, I'm going over by the plant, this covers it?
Well, plant as defined here
As in
in terms
structure.
of,
Yeah.
Right.
Okay.
Yes. All right, so we will revisit the term design, having done the research based on the suggestion as put forward by the Solicitor General.
Yes.
So we can proceed to the other term, which is discrimination.
Let's be clear.
I think
Is it sufficient to move on, or does it come with something new, addition?
no, I think the Solicitor General just asked that consideration be given.
To be consistent where possible.
Design
that's
and
what I mean.
Patents
Okay.
Act, yes.
Clear.
Yes. So we proceed, Mr. Mahon.
So combined disabilities, they raised concerns about discrimination. It is to be defined in keeping with the meaning given in the Disabilities Act 2014. We know we have square bracketed discrimination. So the ministry had responded to say that the Disabilities Act adequately addresses discrimination directed towards persons with disabilities. In the summary sheet on decisions made by the committee on clauses 1 to 118, the committee agreed that Part 6 is to be amended to reflect the prohibition of reprisals by the person conducting the business or undertaking ensuing from deliberations on the ministry's submission of a document entitled Ministry of Labor and Social Security, revised recommendations for amendments to Part 6 of the Occupational Safety and Health Bill, January 31st, 2020. It is therefore recommended that discrimination and its definitions are removed from Clause 4, but based on what we had just discussed, that we may need to keep until we look at the other parts that deals with probably HIV.
All right, that's clear. So we go forward, domestic worker, unless you wish to say something, Mrs. Bennett Campbell.
The term discrimination was actually never used in the bill. It was discriminatory conduct. So what we said we would look back at, I know we had taken out discriminatory conduct and replaced it with reprisals, but we will look, we'll try, the committee, because we had referred to the documents here, need to refresh, everyone needs to refresh their memory as to what transpired in that meeting, and from the minutes also.
So you are suspending deletion of discrimination?
I wasn't really suspending discrimination because it was never used. It was discriminatory conduct.
Okay, so we are still asking for this word to be deleted?
It wasn't ever used.
Yes.
Mr. Chair, through you, with square bracketing, all of that having to do discrimination, discriminatory conduct, and so we'll come back to those.
Notwithstanding, Member Brown, the ministry is saying that the word discrimination was never referred in the bill.
I understand that, but discrimination, discriminatory conduct, reprisal, all of that need to be
all right.
Come back to.
So we square bracket it until we have dealt with that part, dealing with reprisal. Domestic worker.
All right, the bill uses different terms. This is CPC. The bill uses different terms that appear to have the same meaning. For example, in the definition of domestic work, the term household is used. However, the term is not defined. In the definition of homework, place of residence is used. However, the term is not defined. This conflicts with the definition of homework establishment as defined in the bill. So, domestic work and homework as set out in the bill represent two different contexts. Domestic work is work performed by a domestic worker in or for a household. For example, a gardener, a household worker, a chauffeur. The term in or for a household is used in recognition of the fact that all domestic workers will not be required to perform their duties within the private place of residence by the members of the household. A chauffeur, for example, is required to perform his or her duties outside of the private place of residence. A household worker may actually be asked to accompany the family to vacation in a hotel and be asked to perform his or her regular duties. However, this worker is still working for the members of the household, even though the tasks are not performed in the private place of residence. The International Labour Organization has clarified that the formulation in or for a household takes into account that the actual work or services are sometimes delivered outside the household premises, such as example, taking children to school or chauffeuring. See International Labour Office, Geneva, Effective Protection for Domestic Workers, A Guide to Designing Labour Laws, page 11. Now, in relation to the definition of the term domestic worker, it was taken verbatim from the ILO Domestic Workers Convention C-189. And to remind you what the bill says, domestic worker, and I'm going back to the bill now, means a person employed to do domestic work on a professional or occupational basis, but does not include a person who performs domestic work only occasionally or sporadically and not on an occupational basis. Yes. Mm-hmm.
Yes, yes.
It speaks in paragraph A as a person who is employed to do work on a professional and occupational basis, but yet in paragraph B, it excludes. It says it does not include a person who performs domestic work only occasionally or sporadically and not on an occupational basis.
And your specific concern, Mrs. Seeley,
and I don't know what constitutes...
And not
yeah.
on an occupational basis?
Yeah, but I don't... In addition to that, I don't understand what constitutes work. Is this defined occupational basis? Is it? Huh? Yeah, so when you speak, because you see, when you see professional or on an occupant, do we even use that term in our law? I don't understand what is the difference between a professional basis and an occupational basis.
Yes, I actually wasn't finished my presentation yet.
I'm sorry.
I was just reading the definition that we took directly from the ILO. So, however, we concur that the words occasionally or sporadically may result in interpretation challenges, because we know the ILO uses it, but when you try to research it, it is a term that if you translate it into law like this, you're going to have a problem. We also believe that the words occupational basis may also lead to interpretation challenges. The St. Lucia Labor Code defines domestic worker as a person employed for a wage in or and about a private dwelling house. The CARICOM model law defines the term as a person employed to do domestic work in another person's home or dwelling. Based on the CARICOM model law and the St. Lucia Labor Code, we recommend a definition in the bill is modified as follows. Domestic worker could be defined as a person employed or engaged to perform work for wages in or for a household. This definition should incorporate persons such as gardeners, chauffeurs, caregivers, and persons who perform household chores such as cooking, ironing, washing, and general cleaning. It is recommended that the definition of the term domestic work is therefore deleted as same would be subsumed under domestic worker. What we did is we looked at other countries and we realized they did not seek to replicate the ILO per se, and it's probably because of interpretation challenges that it would actually lead to. So we're trying to simplify the definition like other jurisdictions have done.
I actually like the definition that is being
proposed,
so long as we understand what this term household, this is a universal term that has an accepted definition in a convention or something for a household. That's the only thing. That's my only concern.
Well, we could look at it a little more, seeing that we did the research to see what it means, to see if there's something else we could add to the definition.
Yes, Member Gill.
So, Chairman, when I initially looked at the definition, right, I was having problems with it in terms of the domestic helper working in a household, as opposed to the CARICOM model which suggested for wages in or for a household, because you have some persons who employ the domestic helper, but the function of the domestic helper is not confined to the household, but they send the domestic helper to the supermarket or to go pick up kids or things like that. And so my preference would have been one that, speaks about for the household, which would take care of those concerns. But then later on, we don't come to it yet, but the home worker. But we're coming to that definition because I have some concerns with it.
Chairman,
Yes, Member Brown.
our definition of a worker. We know our definition of a domestic worker. Senator Gale is hinting that we're one of our home workers as well. These are matters for the drafters to formulate what is our intent. With the greatest respect to the ILO, in terms of guidance, I appreciate that. But the ILO, by its very nature, these conventions are a major compromise between employers, unions, and government across languages, and for which sometimes the French means this, and the German means that, and therefore the English always stood. So in finding something applicable for us, and we note, for example, that CARICOM went in a certain direction, it's a search to find something that is applicable to us. And we now know that domestic include not just inside the house, it includes, as have been said here, outside on the lawns and the sidewalks where the gardener must work, going on vacation. So it can't be beyond the drafters to formulate a set of wording that would cover this and keep it within the context of the definition of a worker overall and any other subdivision that we want to make of worker. So it's really unfair for us in the committee to contemplate the drafting of these terms. We agree that we need to separate for purpose like registration and so forth of the domestic space. Because as we have said, we don't want to be going into the people's private rooms all the time, except certain difficulties arise there. So can we get a coordination between the drafters and the policymakers that solve this source and bring back something that we can debate?
Mr. Silverbrand, you wish to make a comment?
Well, I'm just going to check the precedent when I'm finished to see if domestic worker was ever defined in the precedent that we're using, because when I look at the definition, in truth, of a person undertaking, a person who conducts a business or undertaking, it speaks to domestic worker. When I look at the definition of worker, I don't see anything here that speaks to domestic worker. So we have to now, when we are going through the bill again, examine how worker is used, ensure that when domestic worker is used, it is used in the context in which it is defined, or it may be that we may need to include in the definition of worker a domestic worker, because it links, the definition of worker links you right back to the definition of a person conducting a business or undertaking, right? So that is something that we have to look. It could have been that these things were inserted at a different stage in the bill. Domestic worker may have been inserted, and we just need to reconcile the definition of worker with it. But as I say, I'm going to have to look at it when I'm going through and redraft and to see. That's the only issue. But I'm going to check to see, Chair, how it was used in the precedent that we used to draft the bill.
Through your Chair, if you take into account Senator Gale's point on page 9, home worker means a person employed to do homework. And without the definition of homework, I'm beginning to think with the back to school. I'm just being tongue-in-cheek there. But what does homework entails?
Yes. Mrs. Benny Campbell?
Yes. Homework is defined means performance for wages of any work involving the manufacture, preparation, beautification, or other aesthetic improvement, repair, alteration, assembly, or completion of any article in premises occupied primarily as a place of residence. So homework represents the work activities that are undertaken by workers in cottage industries which operate from private homes, residences. Note the CARICOM model law and the St. Lucia Labor Code, which also seek to distinguish between homework and domestic work. The issue of homework establishment should be deleted from the bill as the term is not used.
And could I just get an explanation? Because
Yes.
we have worker, we have domestic worker, we have home worker. Can I just get an explanation for why we're having this, all of these? Is it about registration or so that is going to determine the homework and that makes it different from a worker? There needs to be some coherence that we need here.
And before the ministry responds.
Yes.
Because when we came up with these definitions were established pre-COVID. And now you're having situations where employees are working from home. And under the rubric of this definition, it is not aligned to homework. So maybe we want to consider, I don't know if it's a situation where we defined work from home or working from home, but it certainly has to be taken into consideration.
Mrs. Celia Brown?
Making chair. When I look at the precedent and the way it has defined a person who is conducting a business or undertaking, it actually excludes the domestic worker. So it tells me, without more, and because of the way we have defined worker, this draft did not intend to include it. So I think we're going to have to look at the definition of worker if we mean to include domestic worker and put it in that, insert a paragraph to include domestic worker. So when we speak of worker, we mean that it includes domestic worker also. The only issue is, Chair, I don't know, it's drawn from a precedent that didn't contemplate a domestic worker. So there may be some provisions we may have to exempt domestic workers, I'm not sure. But we have to be guided by that. Because in the precedent, it actually excluded an occupier for home to the extent that the occupier employs or engages another person solely to do residential work. That is the precedent that was used to draft this bill. From the, I think
New South Wales?
New South Wales, yes. So
Chairman,
we just have to be mindful.
Chairman,
Yes.
this is Jamaica. Having listened to Bujo, I'm Jamaican. I'm reminded of the other song about this is Jamaica, my Jamaica. How could we contemplate in this Jamaica? And that's true. Or in our Jamaica, we could have a bill that in the definition of worker exclude 200,000 domestic helpers, the people for whom Michael Manley insisted they must get a minimum wage.
But that's why we are here, member.
That's a misadventure that I'm proud of.
That's why we are here.
So I just don't understand how we could even contemplate
That's why it was inserted. Oh, sorry.
the exclusion of these people. And then we say we're for all workplace. So we need to draw breaks and make sure those workers, whether they use washing machine or the scrubbing board of the pre-Independence Day, whether they use the polisher or the vacuum cleaner or the cook, thank you country people have it. The red hook and the wax.
Yes.
You know, in other words, these people must be included. Otherwise, we're wasting our time.
Yes.
So somebody needs to just find a way of fashion
Carol.
that quickly for me.
Yes.
You will recall that this ministry was in here. Actually, well, I won't use the word fighting because the last time I used the word fighting, it didn't go so well. This ministry was in here arguing for the fact that we wanted the power to enter the domestic workplace in certain contexts. Advocating, yes, that's the right word. We were advocating because we said we have ratified C-189. And I know the committee was talking about can you enter, and I know we had said at the time that no country had that power, but research has shown that CARICOM model law and Ontario did allow for the entry into domestic workplace. So we were clear that we were not excluding domestic workers. What we did in 9.2 of the bill, so maybe we need to figure out where we put it. This act applies to domestic workers in 9.2. So maybe we need to change where we have put this thing, because application of the act. So we were making it clear that it applies to domestic workers, and we have always been arguing that point to the point that we wanted to enter under a summons or so forth. So this bill applies to domestic workers. The ministry said we have ratified C-189 and we have to comply with C-189, and we have always maintained that stance. So this bill applies to domestic workers. It's our intent, and that's what we put in this bill in 9.2. But as I say, we may just have to see where it fits.
Yes, Mrs. Seeley.
I agree. And so we would have to fix it by taking out the other parts of it that speaks to the home worker. You're going to delete those words, since based on what you're saying in your matrix, right?
Yes. Mr. Mahon, you wish to speak? I recognize you. Yeah.
Because if you look at the definition for homework, in terms of what it is used and the context, it's really speaking about, and let me give you an example. We had discussed before about persons who have a residential premises and they're using it to carry out garage activity. So we don't want person to say that because this is a residential property, that operation is excluded or exempted and the workers will not have any coverage. In Jamaica, we have what we call cottage industries, and that speaks to these small industries. They may be building craft, they employ workers to be building like craft. They may have shops where they do dressmaking, tailoring, and those type of activities. It is their residential premises, but they actually employ workers who come and they are producing. So they are manufacturing, they're preparing. All right, they may be doing improvement, repair, alteration, assembly, or completion of an article, as we have in the definition. This is not domestic work.
I think that's
so we
clear,
want
Mr.
to
Mahon.
use it to have the context
It's clear.
separate.
Yes.
Two quick observations. Even in that context, even if I do that business from my home, I'm still not taking a business. So why single it out? So is the location determined? So I'm a tailor, and at my home I have 3 other persons work with me. That's still my business, though it's my private residence. So I just want to understand why the singling out. But you also made a point, which we have to be careful though, from a point of law. We have the garage in the residential area doing a commercial business. That's a police matter, because that should not happen by law. So we can't use that as a justification. Because quote unquote, that's an illegal activity. But the tailoring is a different concept. But the garage on the side of the government road in a residential area ought not to happen. So we cannot be catering for them in a bill and legitimize them. So while I understand what you're saying, the example might not be the best.
All right, members. Careful. Mr. Mahon, you have a further response?
Right. So I'm happy that you recognize the principle in terms of what we're trying to achieve, because we have to ensure that we have coverage for workers in these type of activities. So the reason why we made that separation is really because of the whole powers of entry in terms of residential residential premises, especially in the context of the domestic worker. So we don't want, because you have a domestic worker there, you're saying that, okay, we're having a tailoring establishment happening at the home, but because I have a domestic worker there, then no one can enter. Because the law says that if you're going to be entering a domestic space, there's a particular mechanism that needs to obtain in terms of getting like a warrant to enter the space. So when we see, it is clear and evident that this is the activity that's going on there. We see workers going in to that space. They are in the business of tailoring or dressmaking. Then we should have authority to go and do the inspection of this place, because you're actually operating a business.
Yes, Member Skeffrey, yes.
I see you're trying to create a bill that is as broad as possible. Fine. Oh, Andrew leaving? Okay, no.
I just wanted to indicate to the chairman that I had an emergency and had to leave.
Okay, very well, you're so.
So I see where you're going into. we can end the committee. I see where you're going into the highly informal sectors. Because me know what you're talking about. Highly informal. So you're going to rely on, quote unquote, the informal mentality to tell you, or you go and spy to know. Because many of these persons, let's be true, they'll not be registered on GCT and the tax, and you won't capture them. So I know, so how will you really quantify them? To know, because you say you will pass and you will see. While you have the formal business and undertaking, you can easily know them, and you define them by definition for factories, or you list them in regulation. But these, I don't know how you really police it. That's really where I'm going, because how you know?
Well, as you can recognize, that is why registration is so important as well. Because we put, well, for those who would fall under in terms of the informal sector, the informal businesses, if we put an obligation on them for them to register, that in itself would require them to send us that information to know where they are. Outside of that, if they don't do, because even now under the Factories Act, you have factories who may be operating which they don't apply for registration. But once we come across them, whether it be that we are told, or whether it's during the course of us carrying out our inspections, then we visit them, because we have to provide coverage for the workers.
Yes. To clarify what Mr. Mohan was saying, are you saying that one of your rationale for defining and separating homework is for ease of powers of entry for inspection?
What I'm saying is that if you are operating a business, not by virtue of it happening from your residential home, that you're going to use it as a basis to try and exclude yourself from the requirements of this bill. So that is the reason why we wanted to make it very clear that if you are doing these activities, right, you need to register. Not because it is not in a commercial area, or it is formalized, as the member said about the informal economy. You still have an obligation to ensure that we are aware, so that we can do the necessaries to monitor and enforce this bill to protect the safety and health of the workers.
Chairman, just concern. Are we? Those businesses, but for the fact that they don't meet a dollar threshold, would be of interest to the GCT. But they don't have home business, home work, domestic work, and so forth as the categories. So that I feel we are over-legislating. And what we really need to be saying is that these are workers. All workplaces, however defined, are covered by this act. And if you want the specific registration point, we put that there. I don't think we have to be confusing the world, not to mention ourselves, with home worker, domestic worker, worker, because that's all we achieve, and that's not the purpose of law. We must have some clarity, so that if we're saying some businesses that take place in a certain environment, then indicate that those two are businesses. But we don't have to define it as home worker, home work establishment, domestic work establishment. Sorry, domestic work to the left all the time. Domestic work establishment. So we full up this with definitions that confuse, and then some judge may look at it and say, if you have domestic worker separate from worker, it meant that you never intended them to be part of the worker. So maybe the drafters need to get together and pull all of that in terms of worker definition, but separate that from the type of business, and just to cover all the businesses, including the bicycle man, including the tailor, including the garage. That seems to be how it is. And we must bear in mind, while we take the precedents from New South Wales, Australia is a different reality from ours. And so that they may have professional and people, but I don't think anybody in our ordinary use of the language is going to say a domestic helper is professionally, but other term, or occasional, what was the term used? There's a term, professional or occupational basis. That means very little, very, very little, and I'm concerned that we're not Jamaicanizing the thing and taking into account our reality.
Point noted. Member Gail, you wish to say something before I hear from Mrs. Seeley Brown?
No, again, when Mr. Mahon made reference to the right to entry and private premises, yeah? And I remember the discussion that for the private residence, it can't be a situation where it appears as if it's a raid in the early morning. But there would have had to be some notification, generally in terms of procedure. And reference was made around the use of the Public Health Act. And I looked at it, and 20 subsection 2, where a medical officer is satisfied that it is necessary in the interest of public health so to do, he by himself or by some other persons duly authorized by him in that behalf enter any premises with or without the consent of the owner or occupier. That was referenced, but when I look back at it, it's in the interest of the public health and not a situation where you're seeking to go investigate the premises because of a report by a domestic worker. That gives you the right to just arbitrarily enter the premises. Now, I agree with the fact that if a report is there, there ought to be some sort of an investigation, but it don't give you that power of entry as stipulated here in 20 subsection 2 of the Public Health Act. Because I can make reference to it, maybe a situation in that where that resident might be breeding mosquito. And so that ought to be investigated, because that would have been an interest to the public or the public's health. So we have to be careful how we approach these things. And secondly, we really have to tidy up this area that speaks to homework establishment, the home worker, and I have included those who work from home.
Yes, all right. Mr. Mahon, I'm going to allow Ms. Cecilia Brown to respond, because I think the intent of the ministry is very clear as it relates to the domestic worker, domestic work, homework. Well, the ministry is asking for homework establishment. I think you have given an explanation as to what it is the ministry wants to cover. And having regard to the what Member Brown has said, I would want to hear from Mrs. Seeley Brown, because technically this may be for the drafters. The intent of the ministry, I believe, is what you are seeking to reflect here. How it is condensed in the legislation. I would want to hear from you, Mrs. Seeley Brown. Yes.
I've looked at the precedent, Chair, and it's basically the same thing, just worded in a different language. It doesn't define homework establishment. And I think that can be deleted. I think I understand the difference that they're trying to, the distinction they're trying to make between a domestic worker and a home worker. My only concern is when Mr. Mohan raised the issue of entry. Yes.
I think he was trying to use examples. I think we ought not to stray. I think sufficiently we understand what the ministry is seeking to accomplish.
Yes.
So he may have used an example that raised further questions, but I think sufficiently we understand what it is the ministry wants to achieve.
Yeah, and I think when we look at clause 9.2, it is clear. So it applies to domestic workers and to home workers. Yes.
So members, we can agree. Yes.
If Mrs. Seeley Brown could just tell us, are they different from work at 7 and in clause 7? Are the home worker and the domestic worker a different
I'm thinking
breed from the worker definition at clause 7?
But remember, we had that discussion where I'm saying that we may have to include, because of the fact that the definition of worker does not speak to domestic worker, but the definition of person undertaking a business undertaking speaks to the owner of a dwelling house who employs a domestic worker. We already said that there's a little issue there that we may have to tidy up when we get to the definition of worker.
Including 9.2, which says this bill includes.
Yes.
Can't all of that be put in one section or so? Could all of that be part of 7? Clause 7? I don't want to, I'm not trying to argue.
Well, the thing is, remember we were even discussing that we will move all of these definitions to a definition clause, rather than have them as sections in the bill. And then we can have one application clause. Remember when we were having that discussion, that where possible we can move some of these definitions, rather than have them as a section or a clause to the bill, Chair, we can move it to the interpretation section, where it is, because some of them are sometimes so detailed we may not be able to do it in all cases, and then we can then move the application provision further up and do a general application. So we can look at that. Yes. But we have to, however, we have to look at the definition of worker when we get to it and see how it is used here, and whether or not, because we may, as I said to you, because the bill didn't contemplate, the precedent didn't contemplate domestic worker, we may have to look and see where we may need to include or exclude. in some
Well,
cases.
well, it does, I believe, at section 9 too.
No, I mean the
Yes.
precedent that was used, and because we
Okay.
took some things directly from that,
Okay,
it may have, we may have to just do some tweaking. That's what I meant.
Yes, so members, really what is before us is that the ministry is putting forward that domestic worker takes on a definition that incorporates the CARICOM model law and the St. Lucia Labor Code. So that is what we are with. Yes, so the drafters will deal with that. They are also asking that the domestic work be deleted from what we have here in the bill as we have it, and that homework, yes, homework establishment be deleted. And we are satisfied, Ministry, with the definition of homework as put forward here, as is originally stated.
The definition of homework.
Yes.
Yes. Just to also, just to point Ms. Seeley Brown to the fact that it's not just that other primary jurisdiction you spoke of, but the CARICOM model actually does that separation, and it does define homework, domestic work as well. Right. So it is not just to say that we have not Jamaicanized it, Member Brown, but the CARICOM model also looks at and has had the separation of domestic work or homework in terms of its definition.
Chairman,
Yes,
just
Sonia.
wondering where we speak about occupation, premises occupied primarily. Is there a reason we need to reference occupation, the occupation of the house?
What are you referring to?
And definition of homework, we're not looking at that as well?
Homework, yes.
It says in premises occupied primarily as a place of residence. But you may not have someone that's occupying the premises. You could have a premises that's been locked up for years, but you do have people, a gardener who comes and visits. I'm just saying, when we talk about occupied, it could know, I don't know, it could restrict the operation of the application of how you would treat with the premises. Why are we speaking of something that is occupied primarily as a place of residence?
In my mind, I'm thinking they think.
Jen, through your chair.
Yes.
That somebody, for example, yeah.
Let me go a little further. So you have a house and you're running auto mechanic business on the same premises, but you live there.
Yes.
How are you going to say, how do you determine when it says occupied primarily as a place of business? Is that you need to be living in more than half of the property to say you occupy it primarily as a place of residence?
I think it means that you just have to.
As well as I started out first with another concept, which is the whole thing of it being lived in. But the second issue is how do you then interpret further this whole thing of the primary occupation of the place?
You see with the term that primary in terms of it's someone's primary residence. I mean, that was my first understanding of it, it being someone's primary residence, but it is used for a place of work also.
What if nobody lives there?
Well, that's a different situation. That's a different situation now. So in that situation, go ahead, Mrs. Seeley Brown.
Fall under workplace. That's how I see it. Won't it be?
In this situation, you would be using a home as a workplace.
No.
I thought the bill was making a distinction with private premises, these private domestic premises and others. So I think the problem is I think there is not a seamless application of the concepts.
I will come down here and support you now, you know.
Chairman, well, what I thought was really one issue, but it's really two issues with the definition of homework. So right near the end, it says in premises occupied primarily as a place of residence. So the first issue I was raising is, suppose nobody actually lives there. Suppose it's not being lived in as a place of residence. And then Mrs. Seeley Brown said then it would perhaps be a workplace. Except I always got the impression, looking through, even looking at Clause 9, that we were trying to distinguish between private domestic residences and then other places, and not just dealing with workplace generally. My second issue was, again, in premises occupied primarily, if you have a mechanic shop there and you're also living there, is it that you have to prove that more than 50% of the premises is being used as a residence, or you have to show that you live there all the time? Or I'm just saying, again, you're now putting in elements in this that have to be proved. And I'm just trying to understand again the concept. So I had a question about this whole thing with occupied primarily, and I'm not sure if it is, well, I'm not sure what the policy is. And then I think we need some more coherence in terms of how we're treating workplaces generally, how we're treating the private domestic residence, and try and deal with it throughout. Because if we are very clear, you wouldn't necessarily have to even deal with it in Clause 9. If we are very clear from the outset that we're treating, for instance, private residences as part of the whole concept of a workplace, then all we're going to be doing now later on is making sure you protect the right to privacy in terms of entry and a number of other related measures. But again, I'm not so clear about using the terms occupied primarily.
Mrs. Seeley.
So I was with Mrs. Aldred until I wasn't agreeing with her until she spoke to the whole issue of workplace, because in truth and in fact, Mrs. Aldred, based on how it is being perceived, is if you are not occupying the premises as a place of residence, it should be a workplace. However, because workplace is tied to the whole definition of a person conducting a business or undertaking, and we have linked the domestic work in a dwelling house to that, it would mean that you have an overlapping when you look at the definition of workplace. So the workplace could actually be the dwelling house, because you have included in the definition of a person conducting a business or undertaking a domestic work in a dwelling house, where you actually need to draw that distinction for the same reason you're giving, that if it is not if it's not primary a place of residence, the default is the workplace. You understand the point I'm making? So you may have to look at how you have defined, because as I said to you, in the precedent that was used, domestic worker was not included. So the definition of workplace, it would have flowed quite nicely. But because we have incorporated it here, I see where Mrs. Aldred is saying there's not a seamless transition, as if it's not one, it must be the other, because we're kind of muddling the terms by including them. So we have to make a decision.
So Chairman,
Yes.
we now have the situation where we infused the domestic worker working in the household. That's one. And then we have a workplace where you have work being conducted in a home. And then you have another situation where you have this occupied primarily as a residence. That makes it appears of a different distinction, right? And so one would wonder how we separate each of them and how they are applied. And I believe it would have been because we wanted to protect the domestic worker working in someone's residence. That's where we started off. Yeah. So, Mr. Mahan, this is one of your jigsaw puzzles.
Yes.
Same clause 5, I had it renumbered as 4, but clause 5, where it also speaks of the PCBU. It speaks of the domestic worker. It doesn't speak of the home worker. On page 17 of the bill, 5.1c. Well, 5.1 talks about the PCBU, and then it highlights the domestic worker. It doesn't talk about the home worker. Are we to draw a conclusion from that?
You're really sure. Oh, it should speak to domestic.
In the main text, where is there any reference to homework?
So it's defined. Remember, it's a defined term.
Yes, but it must be connected to a provision in the main text. Yes. Where is it used in the main text? Mrs. Benikama? Yes. No, just seeking assistance.
Whether or not the business or undertaking is conducted for profit or gain.
I think it is, I believe it's
9.2. Well, you have home worker. Is there homework? Because we're dealing with homework.
So then why were these distinctions made in 9.2 with define homework, but then we don't put it in clause 5?
My only explanation is that they want to put it after.
I think, yeah, there's...
The bill was drafted.
Yes, Member Gill. Yes.
Listen, I don't know if it's a situation, and I'm seeing it happening now, that we are having the discussion that a bill that is made up as we go along. And there's nothing wrong with that, you know, because what we're trying to do is to improve on a piece of legislation. So let's make the assumption that you started out initially, and then based on consultations or deliberations, there would have been insertions. And it's even happening today that we discuss what is practical, and then chair, based on those deliberations, there are some sorts of understandings, and it requires us to infuse it in the legislation. And that is why initially there was a suggestion that we deal with the definition stage at the end of our deliberations, because it's when it is at that point in time when you make these types of determinations. And based on some of us outlining what is practical, it might inform the approach that we take. That's why we're having this discussion now.
All right. So, Ministry, how do we deal with? How are you proposing that we?
Okay. So, in terms of what Soljan had raised about the primary, just going to read what the CARICOM says under the definition of home worker. In premises occupied primarily as living accommodation. So in terms of the determination, and you mentioned some factors, probably size, but when I look at living accommodation, that seems to me like the hours that you're there, because normally if you're working, the standard is the 8-hour shift. So if you are at this place where is your living accommodation, you will be there for an extended period of time. So it's not the size, but actually the length of time you spend there, because that's where you live. But I do understand the wide point, and this is where, in terms of your the point that was raised by you, Ms. Celia Brown, about the 5, the definition of business undertaking, and the fact about the domestic worker. Well, if you engage a domestic worker, you're not running a business. It was viewed as that you're having an undertaking, because it is not for profit or gain. It's really for the person who is there providing a service to you. But you engage a person for the purposes of wages. But it's not a...
But respectfully, it says, Mr. Mohan, a person conducts a business or undertaking if the business or undertaking relates to the employment or engagement of a domestic worker in a dwelling place. So that owner is a person undertaking a business or undertaking.
Once a domestic worker.
Right. So it goes back. We still haven't addressed what Mrs. Aldred is saying. Hold on. In the sense that throughout the bill we use this term, but we don't use it. But home worker isn't even included in that term.
Well, I was going to the other part, because I'm acceding to what you're saying in terms of that gap. Homework was defined because home worker was defined as a person who does homework in the definition section. So by virtue of you saying homework, and what Member Brown was saying is going to school and doing homework, we don't want that confusion. That's why homework was defined, because we define a home worker as a person who does homework. So it's a bit going around, but it can be represented much better.
No, I'm thinking now that because we, and in clause 9, do you speak to the owner of the person with respect to the home worker too? So the issue I'm having is that we're using this owner of this dwelling house and this owner of a residence in terms of a home worker, but the bill speaks to a person conducting a business or undertaking. And I'm just thinking that we may omit in some cases, they may be exempted in some cases, or not even be contemplated in provisions where we use the PBCU term, because they're not adequately covered in the definition. And I'm thinking maybe, Chair, is it that we probably need to use this this person conducting a business or undertaking, even in the definition of domestic worker and home worker, to make it, to have that seamless flow. I don't know what the fix is yet.
Mrs. Celia Brown,
just quickly, this concept of the home worker, as I hear in the different argument, I don't know how we can really capture that. Because Solgen gave a thinking that is the size. Then we said, no, it's not the size, but the number of hours. But if I have a business where I live, my hours will be ad hoc. So I don't know. So and then how you going to capture the hours that you operate to determine if you fall under the definition? So Senator Brown made a point earlier. Are we trying to bite off more than we can chew? And I'm asking genuinely, because I don't know. If I'm at home and I have my 3 brothers with me and we are tailoring, well, I will live in the same dwelling. And that's where our business is, so that's where the homework is done. But I don't know if I'm going to have any structured time to do work. I can get to 4 o'clock in the morning and work till 8 and then take a break and come back till, because that's where we are. So how will you capture me?
Through you, Chair. So your concern, Members Carefree, is how you're going to regulate.
Exactly. Absolutely. Because talking about registration, and when we get there, but we place emphasis on registration, one, but sometimes I hear from the ministry that registration is not absolute. So I want to know, but clearly, how you regulate this person? That's really the critical question, because you have to have a standardized approach to so determine. I do bakery, I bake jobs and grate a cake to sell at the primary school, and my daughter and niece help me. That's a business, but I do it at home. Would I fall under this law because I have to work as an employer, but how do you capture this person? I think we have it, so you have a definition and you put it there, but in a serious way, how do you define? So you have to have a minimum standard for these quote-unquote informal activities.
Well, Mrs. Silverman, I come back to you because we have heard the concerns raised by the Solgen, but notwithstanding, I think we are very clear as to what the ministry is seeking to achieve. So the question is whether or not, whether we're going to modify section that deals with work or section 9 or 5, can we capture, or even the definition, I mean, as a drafter, are we able to capture the intent of the ministry? Whether as is outlined or in a very, in any way as you, as the drafter, believe is most appropriate. I think once we are there, having regards to the discussions that would have been ventilated, I think we are in a position to proceed.
Agreed, Chair. So I think when we come to the definitions of person conducting a business or undertaking, workplace and worker, we'll have to sit down and decide how we ensure that we capture the domestic worker and the home worker. And then when we're going through now where we need to do the exemptions, if there needs to be any or any inclusions for regulation purposes, regulatory purposes, we have to look at it. But I understand the intent.
Very well.
Yes.
So with that in mind, I think we can proceed. Well, is it ready? Is it 1 o'clock?
Yeah.
That one? Yes. It's ready?
Mm-hmm.
All right. I'm told that, yes, I'm told it's ready. Waiting on you, Skeffrey. I'm told it's ready. Yes. So this is maybe a convenient time, and members. We will have the luncheon break. Yes, we will take them and then we will go back to what we do here. I really do not know the length of their presentation, but we want to give them as much time as possible. Yes. Yes, we may very well, but we, as was agreed last week, we'll have the members of the JGRA and thereafter we'll revert to this. Yes, very well. I understand, Sergeant. Yes. So we will take the break now and we resume at 2. Yes. This meeting is now recessed for lunch until 2. Well, unless members you want to guide the period. I know Member Brown is very specific when it comes on to lunch. All right, so we will return at 1:45, which is 1:45. So we now break for lunch.